of 2014 between Maya Leaders Alliance and 23 other villages and the Attorney General of Belize. Today's panel comprised their honors, Mr. Justice Witt, presiding judge.
Good afternoon, Council.
Mr. Justice Anderson.
Good afternoon, Council.
And Madam Justice Rajnath Lee.
Good afternoon, Council. Good afternoon, everyone.
May we have the appearances, please? Thank you.
May it please your honors, for the appellants is Magali Marin Young, together with Mrs. Monica Koch Magnuson and Mr. Alistair Jenkins.
And on the other side?
Good afternoon. Samantha Matut Tucker on behalf of the Attorney General. Along with me is also Ms. Lisel Alamia, Chair Lady of the Toledo Maya Land Rights Commission.
Yes, and I understand we have the pleasure of having Dr. Solorio, who is the authority in Belize, today present with us.
Good afternoon, Your Honors. Thank you so much for the opportunity.
Okay, thank you. Let me start by saying that we got a few new documents, of course, preliminary report of the authority, Dr. Solorio. We got, and she added to that the procedures for dispute resolution of the authority. We got comments on to the report from the Government of Belize. We got the appellant's compliance report, number 11, and we got a status report, number 9, from the Government of Belize. So those are the new documents that came in. Concerning the third one, the comments to the report, it's clear that a certain I wrote it, but we don't know who I is. So maybe you could, the representative of the government could elaborate a little bit on that. Who wrote it? Is it you?
Yes, Your Honors. It was I who actually wrote the report after consultation with Ms. Alamia, who was the representative chosen on behalf of government to participate in the meetings with Professor Solorio. And I also had discussed the matter with the Solicitor General as well.
Okay, so and at least because in the report it is said, well, my experience, I was there and so on. So it's good to know who then wrote those comments.
I do apologize, Your Honors, for not making that clear in the report.
Okay, well, I already thought so, but now we know for sure. Thank you very much. There is one point which is important for the complaints that need to be dealt with, are being dealt with. Well, that is the point of the contract of Dr. Solorio, who got a contract of 6 months, which expired, if I'm not mistaken, on the 17th of April. And so our question is what is the status? Maybe Ms. Matut, you could answer that, because has the contract been extended or renewed or what?
Your Honors, if I may, at this moment, yes, the contract has expired and approval has been given for a further extension of her contract for another 6 months.
For another 6 months. Okay, yes, well, so that brings me to Dr. Solorio. Dr. Solorio, at least you know now that your contract has been renewed or extended for another 6 months, which makes it possible that you can finish at least the complaints that you have that you are dealing with. And my question, our question would be, I see that you already got all the information you needed for I'm not sure, the first 4 or so cases, and that you were at the point of getting information on the other cases. could you tell us a little bit about the status quo of the cases, when you think we can expect some final decisions and recommendations?
Thank you, Your Honors. The first report will be issued next Thursday, June 11th, and
Okay.
I expect the rest of I actually have 8 complaints right now that I am reviewing. I received a new one this week, but I expect the 8 reports to be released between June and July of this year. I do think it's advantageous that my extension is running until October to give the opportunity to receive additional complaints if this is considered necessary by the appellants.
Yes. Okay, well, that is clear. You expect the first case to be finished around in a week's time, you said?
Yes,
Okay.
I'm going to be ready to release it next Thursday.
Okay, so they will successively be released whenever you finish a complaint?
Yes.
Okay. Have you been in the opportunity to see the comments to your preliminary report?
Yes, I did review the comments provided by the state and also by the appellants in detail.
Okay, so we're not going into all of that here because you are in an adjudicative position, so to speak. So you do with those comments whatever you think you have to do with it. But we will come back to you later on, if you don't mind. There are a lot of issues that were put on the table and that require some clarification, in our view. Yes, just
Mr. Chairman, through you, may I ask of the professor about the process for releasing her report? Is that stipulated in your contract? For example, to whom is it released?
They will be shared at the same time, both with the state authorities and also the Maya representatives. I want to give them an opportunity to provide comments. And then when we have the comments from each side, I would like to share the reports with your honors and the Caribbean Court of Justice, if this seems amenable to your honors.
Yes.
Yeah.
Well, thank you for that. That seems fine to me. Yes.
Yes, well, these reports would have to certainly would have to go to the government and the government entities and the Mayas and their organizations. But in the end, they would have to come to us to see, how things are going, so to speak. Okay, thank you very much. I will come back to you a little later on, if you don't mind.
Thank you.
Yes, so now the several issues have been put forward. We discussed the contract of Dr. Solorio, so that's done. Another point is the so-called customary land tenure policy. The appellants have been saying that there is agreement between appellants and the commission, but after more than a year, the appellants are still waiting for some approval of the Attorney General. So question is, what is the position of the government in this case? Is there agreement? Is there approval by the Attorney General? And then we come back to another point, which would be the funding. And of course, the question is also, what is the position of the Commission? Formally, I think the Commission cannot bind the government. Is that not so, Ms. Matute?
Yes, Your Honor, that is correct.
But in a very practical way, the Commission have done the work, and I suppose that they are both in contact with the Maya representatives and the government. Now, the question is now, okay, if there is agreement between the appellants and the Commission, is this document, the customary land tenure policy, also approved by the Government of Belize? That is something we need to know. Could you answer? Yeah, you have to unmute.
I do apologize, Your Honors. If I may allow for Ms. Alamia to comment on that, Your Honors?
Yes. Ms. Alamia is, of course, the chairperson of the commission. But of course, you can talk. If you unmute.
The commission only makes recommendation to the Attorney General. The final decision lies with the Attorney General's ministry. Whether they feel that it needs to be further consulted within government, that is their prerogative. And they may have, may decide that it needs negotiations, need to continue, or dialogue needs to continue, because they may or may not agree with certain aspects of the policy. So I would just list that as a recommended policy from the submitted by the commission, but not final.
But if I'm not mistaken, it was submitted more than a year ago.
Yes, it has been submitted for a long time.
So, although of course we respect all the difficulties governments have to encounter, given the fact that there is a binding order, one would expect some clarity from the government. Now you are in the commission, so you cannot give that clarity, I suppose.
Exactly.
Yes. So then I get back.
No, and I have alerted on numerous occasions the Solicitor General and the Attorney General that this is a matter of priority, and that we would appreciate some response, since of course we are the ones who are in regular dialogue with the Maya leaders.
Yes.
Ma'am, if I may, Mr. Chairman,
Of course.
I have what is called a final draft of Maya customary land tenure policy in southern Belize. That is the document you're speaking about, and that has a date of the 15th of February 2019. Is this the draft you speak of that was recommended to the with at least that went with your recommendations to the Attorney General?
That is the correct name of the document. Whether that is the correct version, the date, I don't have that readily available. But yeah, so that is the document that referring to. Whether that is the version that was the final submitted to the Attorney General's, I can't say with certainty. But it has been a long time, Your Honors, and I would say that at least a year.
And what I gather from hearing you speak then, ma'am, is that when this matter is approved by the government, that the appropriate official of the government, be it the Attorney General or some other Justice Minister, will sign off on the document?
Well, the process that I am familiar with is that once I submit this to the Attorney General's ministry, first I submit it to the Solicitor General. Her office will then review it and decide whether this is acceptable to government. And she may decide that she needs to consult with her minister, who is the Attorney General. And they may also decide that this needs further consultations within government. We did the best we could in trying to consult a wide representation of government officials that we thought would have the greatest impact in regards to Maya customary lands. But they may decide that there are more people that need to be consulted.
Yes, we understand that, but whatever they may or may not do, they should have done it by now.
Yes, Your Honors.
Because we want to, of course, we want this thing to be serious. And and the other side, the appellants have expressed feelings of anxiety and wondering whether they are taken seriously. Of course, a lot of work has gone into this, and not the least by you and your commission. So the least one can expect, if the government has some worries or queries or worries, then they should have expressed them so that we can finalize it.
If I may, Chairman, I understand what you've said, Chairperson. I just wanted to ask a question which goes off at a slight tangent. This customer land tenure policy is obviously under consideration by the state. In your view, what is the relationship between the approval of that policy and the other steps which are necessary to be taken to give full effect to the consent order of 2015?
Do you, just to be clear, you want to know more or less how close we are in our recommendation to it perhaps being approved?
No. What I'm trying to get at is the pivotal role that is to be played by the approval of this policy. In other words, I am wondering, for example, whether the delineation exercise, the mapping exercise, is contingent upon the approval of the policy, because unless we know what we're talking about in terms of customer land tenure, how do we know where to map? So I may be wrong, you're shaking your head. So I just want to get an idea from you whether you think that the approval of this policy is a condition precedent for other elements
No.
to go forward.
No, in my view, a lot has transpired in the work that we have done to date since that policy, that in my view, certain aspects of that policy no longer apply. So when we approved it in February, we were at a certain agreements. And now as we have advanced, for example, with delimitation and methodology, there are certain aspects that are reflected in that methodology that contradict what is in fact in the policy. But I didn't want to go back to the other party and do it in a piecemeal approach, because those are things that I was hoping the policymakers would give more directive to. So, but it doesn't hinder what in proceeding with other critical work that has been agreed upon. For example, it does not hinder what the demarcation and delimitation methodology includes and the process that we have agreed to. It also does not affect the advancements of the FPIC and what is included in that. So to me, the priority in my view, Your Honors, is the delimitation and demarcation, because the way that is written, it will address the different nuances and realities within each of the different communities that are claiming customary land tenure.
I see. So, in other words, the delimitation exercise is geared towards identifying the areas over which this customary land tenure policy will operate. And it will define the rights of the Mayan people in those areas.
Yes.
Right, okay.
And could you remind us what is the status of that policy?
Of the demarcation and methodology?
Yes, yes.
We have agreed, that has already been agreed by the commission. That is not being advanced to the Attorney General because we believe that we have the jurisdiction to enter into that agreement. And only if we believe that we reach an impasse as this process unfolds do we believe that it may be necessary to go to policymakers. But at this point, that process can commence and the monies are available. And so the onus now is on the Mayas to take lead on it. Our role at this point is to gather the maps of the areas so that they are aware of where third-party interests exist within these communities. But that doesn't prohibit them commencing their work.
Okay, now according to the appellants, this document, delimitation principles and methodology, was signed by them, but not by the commission, probably because the commission doesn't feel that they could do that. But the commission, as I read it, has told them that the government approves of the document. Is that correct?
Well, the commission approves, yes. The commission approves of the document, Your Honor. We did agree at the commission level that initially we were going to sign off at the document, but because everything becomes litigious and every word is then becomes an argument, I did not feel comfortable with signing off on this when this document is really to be a dynamic document that responds and adapts to the realities on the ground.
Yes, but as you say, you cannot sign, it's really the government who has to approve it at least. According to what the appellants are saying is that the commission told them that, don't worry, the government approves of this. Now, I read in the report of the government on the draft delimitation principle and methodology that a final draft has been developed. The latest education is expected to guide the delimitation principle and methodology. All parties are, however, in agreement that the methodology may need to be amended as the process unfolds. So, what is the situation? Is there an approved, also by the government, approved document? And is it agreed that as things go on, it might be adapted or amended in a later stage? Of course, people have to know.
Yes, as I stated earlier, Your Honor, the commission is of the opinion that this is a decision that can be made by the commission, and that therefore the commission can enter into an agreement that this is the methodology that will be used for identifying Maya lands. We did not feel that it is necessary for it to go to the Attorney General's ministry or to go and be circulated back to government, since they don't have the benefit of all the details and experiences that we have on the ground. So you're asking me whether the government, if you're differentiating, which is fair to say, differentiating between the government and Belize and the commission, I believe, and we're of the opinion, that the commission has the authority to say to the Maya leaders that we accept this methodology and therefore you can proceed with the work of delimitation and demarcation of the lands.
Okay, now Ms. Matute, as a representative of the government, if you say, well, the government agrees with what we just heard, then we can put that down.
Honors, well, it is that I was not aware of what was transpiring in relation to the methodology report for the policy, I cannot say that it is not within the scope of the commission if they are of the view that they are able to enter or at least participate in the process of this delimitation or demarcation policy, then we would want to be in support of that.
Yes. But anyway, but if the government doesn't approve, for whatever reason, we would like to know. So,
Your Honor, well, since the document has not been shared for us for approval, then at this point we cannot say whether we approve or we don't approve until that takes place.
how is
I'm
it
sorry?
How is it possible that it has not? You don't know, because this is a case not between the commission and the Mayas. This is a case between the Mayas and the government. So the government could say, well, at this point we leave that completely for the commission. Whatever they agree, we agree. If the government says that, fine. But the government cannot say, well, actually, we don't know anything about this. Because in the end, it's the government who needs to sign, it's the government who needs to do something, it's the government who has an obligation under the order number 4. So if you cannot give us an answer now, then we would request you to be clear at the next occasion, which should not be too long from now. And the same with the other document. If the government, after deliberations and looking at it, has queries or whatever, then everybody would like to know. If they agree with it, we also like to know. That gives some certainty in life, and that is something you need sometimes. I had another question about that policy. We clearly heard that the other projects are not really dependent on that policy, but there was some mention of funding. Now, is it that it may have the fact that the policy is not officially approved? Does that have any effect on funding? Because there is funding, there is already funding of $1.8 million US from the International Land and Forest Tenure Facility. But the government itself says in its report, the government still has to identify additional funds to carry out inventory of third parties and to conduct verification. That is said under number 1 of their remarks, customary land tenure project. So, question?
If I may.
Yes, of course.
The $1.8 million is sufficient to commence the project. We wrote that we will need to seek additional funding because we are, based on our calculation, the cost would be greater than what we have allocated within that land tenure facility monies. But it shouldn't affect the commencement of the work. And I would think that this money has bought us at least 1 or 2 more years before we're at any crisis without having money to do the work.
Might I be clear on what work we're talking about?
The delimitation and demarcation, the policy, everything as it relates, the FPIC, everything. The project basically identified all the activities that we would need to carry out. We had an agreement, we call it the Agreement of December 2018. In that agreement, we outlined what would be all the activities and deliverables in order for us to come into compliance with the consent order. The proposal submitted, the monies received from the land tenure facility basically funds 80% of that work.
Now, I want to, not to interrupt, but I want to be clear. I understand you to be saying that one aspect of the work is the delimitation exercise. Now, you have said that in your view, the commission has the competence to decide on that in consultation with the Mayans, and that has been done.
Exactly.
So that what now is needed is, unless the government has an objection, it seems to me, and from what Council said earlier, I did not think that she was raising an objection. In fact, I thought she was saying that it was fine for the exercise to go forward. Am I wrong, Council?
Yes, Your Honor, that is what I was saying, but having heard what Justice Witt has said, and wanting to be sure exactly what is the government's position on the policies as it relates to the customary land tenure as well as to the delimitation or demarcation policy, I'd want to definitely take instructions on those before I commit to any final approval being granted or being given.
Your Honors, I think that one of the things that we have been trying to do at the commission is to ensure that we make the process, even within the bureaucracy that exists in government, is to say there are certain things based on our terms of references that we have the authority to engage with in regards to the the recommendations. So we are of the opinion that the recommendations, that we are not yet ready to make a recommendation to government about what lands should be identified as Maya customary land. Our terms of reference says that we will make a recommendation to the government of Belize on what lands. It doesn't say that we have to tell them or get their approval on what the process is to arrive to that recommendation. And so I am trying to be very careful that we don't get bogged down in having
Exactly.
to go back to the attorney generals
Exactly.
for every decision we make. That is why I, with all respect to Honorable Witts, if we are opening that box whereby we have to take this matter to the attorney generals, I'm going to tell you that we're going to probably be sitting here at least 6 months to a year before they arrive at a decision on this. It's just the speed and the nature of how government works.
That's
And
exactly.
that is why I have been trying to state that as far as we understand, we have the authority, we have the terms of reference that give us that. I mean, I prefer ask forgiveness than to ask for permission in certain matters.
That's
Okay,
an interesting way to put it, Chairperson. But you know, I would have thought, and I didn't think that the chairman was trying to give you legal advice, counsel. I would have thought that there might be enough there for the process to go forward. Because remember, the chair of the commission is saying that when that process has been exhausted, the commission will then make recommendations, which the government may accept or may not. But at that point, the government then comes in. But in order for the commission to be able to make recommendations, this exercise needs to be carried out. So with the reformulated view of this, would you, representing the government, have any objection to the exercise going forward? I think that's where we're at.
I see, but then when you open it to the council, she will have to say that she has to go to her bosses to get their approval, and then this is where I am just sitting here wondering,
Yes.
oh my God, where are we going? Because she can say, well,
But to
In
put the
this
matter
case, it
another
would be-
way, if the matter was to proceed in the way that you anticipate, I assume that if the government had a difficulty, they would, during the course of that activity, communicate with the commission.
exactly.
So to get the matter moving, should we not proceed in that way?
That's how I'm proceeding, Your Honor.
Thank you.
well, I also have to,
Perhaps we could, yes.
yeah, I also need to point out, of course, that the grant of 1.8 million was received with the support of the government. So I suppose that shows that they basically agree with the process. So I agree with you that in order to go forward, we don't need the government, but at some point they will have to let us know where they are.
So through you, Chair, if we were to adopt your modus operandi, Madam Chair, what is the very next step in relation to this aspect of the matter?
The next step, the majority of what remains in regards to demarcation and delimitation, the largest portion of the work that can be done in the next year is totally the onus of the Maya leaders.
So
If nothing happens, if nothing mobilizes, they can't come and complain about us.
Yeah,
But
but
perhaps, Mr. Chairman, we could hear from Council the Mayans, yes, because
Yeah.
I think she wishes to be heard.
of course, but, I'm providing her with the material to.
did you say the material of the ammunition, Chairman?
But
I
before,
see what you're doing. I see what you're doing.
well, the point is, I don't like to talk in the abstract, and I like to hear concrete things, you know. But before we go there, so we have talked about these two documents. Maybe we can go to the free prior informed consent protocol, and then you have your turn to look at that. What I understand is that there are apparently some misunderstandings between the parties. There is a very advanced draft for a protocol, free prior informed consent protocol. There is one part, there are 2 points. This is some discussion about who is the final decision-making body on the side of the Mayas, which is the TAA or every village separately. There, the appellants have said something about that they say, well, if it is something that concerns one village, clearly it's the village. If it concerns something more than one village, it is the TAA, and that is already somehow in a document. That is one point, and then there is an issue of a grievance and redress mechanism where both parties seem to wait on each other. But I suppose that those kind of things could be solved very quickly. Once we have a clear understanding who is going to do what and when, then that document could be completed fairly quickly. And then we have at least a document where you can work with. So let's not go into who has to do what, but I think we should try to focus on, or let's not focus on who did something wrong, but who needs to do what to make the next step. I think that would be more fruitful. Well, we saw the point of view of both sides. So maybe counsel for the appellants could go into the question, the matters that we have discussed.
Grateful to your honors. Indeed, the appellants stand ready to flesh out the grievance redress mechanism. But given that this entire process has been one that involves dialogue between the parties, the commission had worked out a final draft of the free, prior, and informed consent, and the appellants gave their feedback and were simply awaiting to find out if that feedback had been accepted. If it is that Madam Chair is prepared to say yes, the feedback or suggestions, or to provide us with any revised draft based on the feedback that the appellants gave, the Maya appellants stand ready. They have been working on that mechanism. They did not want to be working in vain, and out of respect to the commission, wanted to ensure that there was feedback to finalize and send them a draft.
Should I respond?
I am told from the appellants that they would be able to submit within, if not less than a month from receipt of the final draft of the free, prior, and informed consent.
So what is your concrete step? What is the concrete proposal? Who is doing something first?
So your honors, what my understanding is that the parties have, as you said, have a well advanced draft, and a final draft was submitted to the appellants, and they gave their feedback and some recommendations, and we're simply awaiting the response from the commission. But they stand ready to jump on the grievance mechanism once they've gotten that response, and to bring this document, a very important document, to some conclusion. So
it might be useful, counsel, not to interrupt. I'm sorry, not to interrupt, but it might be useful just to hear from Madam Chair, so we can get this matter to some sort of finality. Yeah.
Well, Well, first of all, with all due respect, it is very misleading to say that the parties have been sitting there waiting for us to respond. The matter we have responded, as they are well aware. We use Mr. Fergus as the mediator and the means for communicating and negotiating where we stand on our positions in regards to all matters. That is why we have been able to make, in my view, some significant advances. And we have made it abundantly clear that there are certain recommendations where they're insisting on, or certain positions that they have taken, whereby we as a commission are abundantly clear that those are not recommendations that we will advance to government. Therefore, if, for example, there are certain things that we don't agree with and we need to take it up to policymakers, then that is where that will go, right? So, for example, the most particular position is the fact that we are of the view that the autonomy of the village must continue to exist and be protected. Whether you have 5 communities that are going to be impacted, then that is a matter of fact and logic, that you will involve the 5 communities that will be impacted. That doesn't mean that it goes to the Toledo Alcalde Association to make a decision. They're insisting on that. If they want to insist on that, then they need to make that abundantly clear, and then we would have taken that up to the policymakers, because that is where, for example, I would call it an impasse, where the commission is not willing to make that recommendation that they have put forward. In regards to the grievance and redress mechanism, one doesn't have to do with the other. They could have by now submitted a draft redress, grievance and redress mechanism. We had asked Mr. Fergus to prepare a grievance and redress mechanism, but we said, if we are going to try to build trust and be more inclusive, then let us give them an opportunity to have a first draft with the grievance and redress mechanism. This is months ago, I don't know, 4 or 5 months ago. We have not gotten a first draft. So to put the onus on us because they have not prepared their grievance and redress mechanism is totally unfair.
Okay, well, let's not talk about that, but let's talk about how we can get to a result, because that is that's the more important part.
Yeah,
So-
Your Honors, but if I may speak up in relation to the free, prior, and informed consent. This is a very important document for the appellants, and it is not. My understanding is that the commission had adopted the 2014 Maya consultation frameworks position on the free, prior, and informed consent. And it was never an issue that the Toledo Alcaldes Association would be included in decision-making if more than one village was impacted. And the reason for this is it has nothing to do with any administrative position in terms of what we traditionally know as village council. It has very much to do with Maya tradition, that the community decides when one or more villages are affected, then the association has to get together and it becomes a community decision. So for the appellants, it is of great, it's surprising, having seen the draft where the 2014 Maya consultation framework was adopted, that this is, the commission is now opposed to this methodology in terms of decision making. If this is a new position, then clearly the policy, well, as Madam Chair has indicated, it may come down to a policy, but it is what the appellants are trying to achieve is what is in fact their decision-making process, and they thought that it had been adopted, say for some minor changes to the framework. For the appellants, they wish to get this process going because, as your honors would have seen in the report, it has grave consequences for concessions being given and purported consents being extracted from the Maya.
Council, if I may, sorry to interrupt, but Madam Chair, based on what was just said, does the commission, I'm just trying to get clarity, does the commission have a difficulty with the procedure that council has just laid out for the FPIC?
Well, I think council, with all due respect, is totally misinformed about what has transpired during this process. The commission had made it abundantly clear that we would not accept the Maya customary, I forgot what their document is called, of the document of 2014. And we had said to them very clear that FPIC is a process that needs to be led by government because it's a process that government has. It cannot just take their document and adopt it. What we said we would do, and we committed to that, and we used that we would use their proposed, or what they call their FPIC, as a resource document. And your honors, we took at least 75 to 80% of what they had in their documents. There are other sections that we did not agree, but Mr. Fergus then used their documents and his experience and drafted an FPIC based on consultations between both parties.
And
So-
where is that document now?
Well, the document, as far as I'm aware, the document is now parked. We call it, it's parked because the mediator has said to them, this is our view in regards to the role of the TA in the FPIC process, right? And he is saying, look, he has said, look, let's not continue to waste time or spend time on this when there are other things that we could advance.
Right. Could I
Right?
just,
That-
not to interrupt you, Madam Chair, but could I just ask Council, are you familiar with that FPIC document that Madam Chair is saying has been parked? You have
Yes,
serious objections to it?
Well, we have objections to it being parked because this is a fundamental document that is crucial to compliance with paragraph 4. Because paragraph 4 of the consent order expressly requires.
Council, sorry, I understand that. What I'm asking you is, are you familiar with the content of the document to which Lady Chair made reference?
Yes.
And is that acceptable to you?
Well, my understanding, Your Honors, is that the document has been, the final draft that was submitted to the appellants was pretty much acceptable, save that they had some comments in relation to it. They have not gotten a feedback in relation to that, those comments that they made.
But how critical are those comments? Are those comments of the nature that you would not want the matter to go through unless they were resolved to your favor? Are those comments not at that level of importance? I'm just trying to see, well, what is holding this up? Because it seems as if both sides agree on it. I'm not hearing you.
Yes, I'm sorry, Your Honor. From the appellants, it appears as though the comments that were made in relation to that draft do contain some important issues which they would want some feedback on. And, you know, that is why they have not moved on to the grievance. I hear what Madam Chair is saying, and it's true there. One could be developed, and my understanding is that one is being developed, but it is crucial because they both go hand in hand. It's crucial for the the free, prior, and informed consent document be signed off, but it can only be signed off if the appellants get a feedback.
Well, I think, we cannot keep waiting for each other. So if you have comments, did you make those comments already to the commission?
Yes, since November of 2019.
In
my-
writing? In
Yes.
writing?
Yes.
And you say the commission...
Then in January of 2020,
yes?
further documents were sent.
Okay, and you say that you are waiting for a response of the commission on those points?
Yes.
Okay, now, Madam Chair, do you know about these comments?
Yes, I'm aware of those comments. They have been going back and forth, and we have been using the mediator, Mr. Fergus, to relate to us what our positions are, what our position is to regards the points where we have, where, as I stated earlier, are a no-go as far as the commission is concerned. It doesn't mean that if you keep sending it back to me and keep sending it back to me, I'm going to be changing my mind.
Okay, so you can only change your mind if you take it up to higher echelons, and then probably it will take a lot of time before it will go back. Correct?
Exactly.
Yeah. Okay,
So, Council, the question is, are the issues of a nature that you are prepared to take the time that it will inevitably take in sending these up to the policy making level? And we know how things work, that might take some time. Or are they not of that kind of nature so that you can proceed based on the basic consensus you have on the document?
Well, the FPIC really has to be taken up higher. That is a very critical document, as it's a document that is going to be the basis of legislation that will be drafted.
No,
right?
I understand, but
So-
I assume that the going up higher would be facilitated if there was consensus between the commission and the man leaders. Is that not so? If you could both agree on the FPIC, and it goes up with the blessing of yourselves, man leaders commission, is it not more likely to be more favorably received?
I agree, yes.
Yeah, so
But we have had various iterations of this document, and there are some points where we have made no advancement. We are both, I guess, hard and fast on our positions. What is the situation, Your Honors, is that the matters that they have asked and their positions that they have taken, they have been advised by Mr. Fergus that those matters cannot be converted into law. And in fact, so why would we agree to something in an FPIC that when the final goal is to make it into law, but we know from now that it's not something that can be included in not, and that in fact it doesn't come into the compliance with the UN Declaration on the Rights of Indigenous People. It's not part of what would help us come into compliance with the consent order.
I know that counsel for the appellants wants to intervene, but could I just say one more thing? Would one possibility be, if you cannot arrive at consensus on all the points, that the document goes forward with the alternative views being expressed in it, so that the policymaker can make a decision one way or the other? If that decision is made,
Yes,
and the
but-
man leaders, for example, do not agree with it, then of course other options might be available to them.
Right, I agree with that, but that's why we want the grievance and redress mechanism, because in my discussions with the Prime Minister about this matter, he asked me very clearly about the FPIC, if it also addresses grievance and redress mechanisms, and I said that it doesn't. That is why I came back and I said, look, in order for this, FPIC cannot stand alone and will not get political support if it does not have the grievance and redress mechanism as a component of it. That is why we sent it back. So it can't be handled separately. So yes, there's nothing that stops me, and in fact, that is the intention, to say to government, this is the recommendation of the commission, this is the position of the mayors.
Okay.
As a policymaker, you decide and instruct us.
Okay.
Okay, but I assume that there are many points that you do agree on.
Sorry, you broke up for a minute there, Honorable Witts.
Yes, I was saying that I assume that there are many points that you do agree on in this draft.
Yes.
But anyway, to go forward, and we cannot wait till eternity. So what needs to be done is that there needs to be a grievance and redress mechanism drafted. I think the appellants have at least made clear now that they can provide a first draft on that point. So the question is, when could you do that? You could also try to once more to get some agreement on other points that you do not agree on. But if you don't agree on that, I think, well, that is what you could do. You could then say, okay, well, on those points, we will leave it to the policymakers to decide that. At least you would have a document which could be used in a preliminary way, which could be used for the time being, so that you would have something better maybe than that you would have now. But that is just something that you could consider. This is not that can be imposed.
Your Honors, for the appellants, they up until today, they did not realize the document had been parked. But what they have, they believe that would be helpful to them is if Mr. Fergus could in fact send them the final draft with the Commission's proposal and also what their issues are and which they wish to have addressed. And, you know, if that is sent, that would be very helpful to this process. They are prepared to provide a draft of the grievance redress mechanism within a month. They are prepared to commit to that. But ask that if Mr. Fergus could please send that draft for them to work off. So if the appellants could get that would be helpful for them to get the grievance redress mechanism.
Perhaps Madam Chair could give a commitment in that regards.
Is it possible to unpark the car?
It's possible. Am I?
We're not seeing you, Madam Chair.
Okay. Yes. I could ask Mr. Fergus, even though I think that we're at the point where we're at the point now where what is our final position has already been submitted to them. But we could resubmit to them what we consider our final position on the matter.
Within a week?
They already have that because
within a week, Madam Chair.
Definitely, Fergus is very quick, and I'll work very quickly with him on that.
Okay, so within a week you will send the parked draft plus any comments, and you could, if you already made them, you can just refer to them and add a copy of your earlier comments so that we know this is the position of the Commission, and then within a month after that, we will get from the other side a draft for the grievance and redress mechanism. And then
but perhaps they can also commit on how quickly they're going to respond to us on it, so that if because I don't suspect that we will agree, the Commission and the Maya leaders, on what I am sure the points will continue to, there are going to be some points that we will disagree on. And so that we can, even though, no, I recall that, because we won't send that forward until we have the grievance and redress mechanism.
Yeah.
You won't send what forward? The
FPIC.
FPIC. You
the
mean?
Prepare Farm.
Yeah, you won't send it up to the policy makers. No, we understand that. So you will send this draft plus your comments in whatever form within a week to the Mayas. They will, within a month after that, send you a draft on the grievance and redress mechanism, and I suppose answer the comments that you have, or they might even suggest a compromise. You never know, but that is up to the parties. But at least we will get some speed in this process.
So just to, with your permission, Chair, just to sort of draw a line here. So we're talking about 5 weeks from now, and at the end of those 5 weeks, we will have at least the first draft of the grievance and redress mechanism. We will also have the FPIC document, both the final position of the Commission and the position of the Mayan leaders. And I assume, to the extent it has to go, and you have said it has to go to the policymakers, it will be sent, both documents will be sent to the policymakers. This is what, middle of July, by what, the 1st of August?
Well, I don't know what they will have. I don't know how, since we don't have an idea of what will be proposed in the redress and grievance and redress mechanism, I wouldn't want to commit that we would be able to turn that around.
End of August?
That space. I mean, we can aim to do it. We're very quick at responding to things on at least on the commissions, and what is a lengthy process is a process that the Mayas use in regards to consulting their alcaldes. So, and I imagine that their grievance and redress mechanism would need to be consulted. And I don't know with the times of COVID, whether realistically that could happen then. But we, on our end, we can commit that we are going to do everything to advance it as quick as possible. So,
Okay.
at least with the commission, yeah.
Okay, well, at least within a week you will send your stuff, and then within 1 month after that, the appellants will send in their text for the grievance and redress mechanism, and their reaction on your points, or maybe even suggestions for something in the middle. You never know. And if that is the case, then you might have to discuss that again. But at least there will be some speed to get the document done. And if it, at least if we have something agreed on, if only provisionally, with some points that are still under discussion to be decided by the policymakers, at least we have something in writing which could then be used, you know, for the time being in this area. So then we have more than we have now.
Mr. Chair, if you would allow me, there was a matter where there did not seem to be any hindrance in progress being made, and this is in the delimitation and demarcation.
Yes.
And I think we were to hear from council for the Maya as to how and when that would proceed, because we're particularly interested that is a key component in this matter, ma'am, and that progress should be made, proper progress.
Thank you very much, Your Honor. The delimitation principles and methodology, as far as the appellants are concerned, have been fully signed off. What the appellants and the concern keeps being and has been raised was a formal commitment from government. But from what I'm understanding, that this particular document, as far as government is concerned, there is a commitment and the Maya people can act on it and proceed, and the land tenure facilities funding could then be accessed to carry it out to the next stage, the auto delimitation process. So for the appellants, they are glad to hear that there is that formal commitment that enables them to nudge the land tenure facility to access the funding to then move quickly in the auto delimitation.
Okay.
I know it's a technical matter, but can you give us any more detail as to what the next practical step is?
So my understanding of the next practical step is the appellants have already gathered the equipment to do the GIS, the mapping, and to put that together to put to the commission and government so that they stand ready. And they are very advanced, I am told. Their villagers have been active in this process, so that with continued funding, I believe they would be able to complete this process. How soon? The project timeline is for 2 years to complete this auto delimitation process. So, Your Honors, it is hopeful. It is now that there is this formal commitment, and now that the appellants will be able to access more funding, it should be well on its way.
If I may say, I may have misheard you, but and I'm happy to be corrected by Madam Chair, but it seems to me that the only point of contact for you at the moment would be the commission. If I'm wrong, Madam Chair, but based on what you have said earlier, the government's approval comes in a little later. Right now, at this preliminary stage, the point of contact is with the commission. Am I wrong or right, Madam Chair?
You are right. You are right, Your Honor. The process, if I don't know if you want a little more detail on the delimitation and demarcation policy, the way it is done is that basically they're going to identify their own mapping team. They're going to set up their own GIS within their within Holy and Trust Society. They're going to do training on whatever is required within their communities to bring the expertise in to support them. They're going to divide the area into regions. Those regions will then be submitted to us so that we can request from the lands commissioner the maps so that they're aware of third parties. But they are going to go, there's a whole process that is outlined in very detail what the first steps are, how they when they enter the village, what is it that we as the commission require, and then we are also going to go in as observers to the process so that we are confident in whatever it is that we can recommend to the government and say we are satisfied that this is a process that was transparent and inclusive. And so, but we're hoping that the process that we have agreed upon will be will work. We don't know if it will work. We're hoping that it will work. What we did was to say, because generally what would have happened is that the Mayas would have gone in, or the process in this instance generally would have been led by the Government of Belize. And of course, we would be in conflict about who said, she said. So we said, okay, you take the lead on this. We will go in and observers to be satisfied that you have been transparent in your process. And in each step of this process, we're going to be writing off and says, in San Marcos, we're satisfied that people were given the correct information and that we had fair representation in the village, that people were allowed to speak and to participate freely. And then, so that's one step. First, the communities will have to agree if they even want to participate in the process. Then, of course, we come in, then they do their mapping exercise, etc. And we come back in. We don't go to all their meetings. We come back in to verify that what they have stated and are going to present to us is what the community also agrees with. And then we may or may not agree with what is being presented to us. And we may, if we don't agree in it, we will have to put in writing as government to state why is it that we don't agree with that, what they're presenting forward. So with the exception of the maps of third parties, for right now, that is the main thing that government's responsibility is right now, to give them all the maps to show who are third parties, who have leases, titles, whatever, concessions, and to provide them with that. But that really doesn't prohibit them from going in. And as they have told us over and over, in many of their villages, these villages have knowledge of where their boundaries lie. Also included in the process is an agreement between the villages so that government is assured that any conflicts between bordering villages have been resolved between the parties. And so that then government doesn't have to come in and become involved. We're hoping that they can resolve it amongst themselves.
Now, the way you have spoken suggests that there could be different levels to this mapping process, because first of all, the Mayan leaders will do the exercise. You will have some impact and influence there, of course. But then afterwards, you may also want to do some verification, if you will.
Yes, we call it verification.
As well. Okay, so the
Yes.
question then is, when Council spoke of 2 years, is 2 years for the entire set of activities, or 2 years just for the activities by the Mayan leaders?
Well, I think they said the Mayas are of the opinion that they can do the 40 villages in 2 years, and that would include everything, including the commission bringing forward to government, tabling to government. These are the boundaries of villages, and we would recommend that you register them. Of course, the Mayas are also aware that that process would be incomplete if there are outstanding matters with third parties, or if there are continued dispute between villages. But if all goes without any major hiccups, then that is the timeline that the Mayas believe is doable on there. And I think it's very, very ambitious, but
Yeah, sounds like it.
it's very, very ambitious, but I think the donors, so forth, realize that it is very ambitious.
Okay.
But at least let's aim to do that. And the donor, it is my understanding, are always willing to give extension for project timelines.
Yeah,
But
and
that is why we also said that there will be need for additional funds, because the process may take longer, which means that this project will not cover all the costs regards extension.
Yes, and let's start now. I think that's the message as well. Let's start. This is something, as Justice Rashad said, that everybody agrees on. You know, let's start while the iron is hot. Let's strike. Thank you, Chair.
Exactly.
Yes, Madam Chair, just let me know then, at the end of the day, these 2 years and the 40 villages that you spoke of, what is intended that you should have in hand that you can send to the policymakers? Agreed
Maps of each village.
Okay. You're not talking about surveys.
Well, we are trying to get based on the legislation that exists in Belize, and we're going to try to advocate for new legislation so that we can use existing technology instead of on the ground survey lines. Because if we have to do on the ground survey lines, then that's going to take forever. And so we have been told that there exists some more advanced ways of identifying lands with using GPS and using remote sensing information. But no, the intent is not. The villages, the Mayas had indicated that between the villages, they are going to clear their boundary line. And then when we go in to verify, because we will then hire a surveyor to go in and verify the information that they're providing to us. So the clearing of the boundaries, etc. That's the intent. But we are hoping that we can use technology instead of these basic surveys. I don't know how you call that. Just cutting lines and using the traditional surveys approach, because I don't know when that would ever finish.
And where you do have no consensus on the boundaries, are you putting in place, or have you put in place between the parties some sort of formula for mediation or for determination of it rather than it ending up in court?
And yes, if I recall, we have sent that. Yes, there is a mechanism included in that delimitation. But again, what Mr. Fergus has advised us as much as possible for government or any other party to stay out of whatever conflicts may arise within the villages and have them resolve it within themselves. So only as a final approach would we want to activate bringing somebody to resolve those conflicts.
Okay, well, talking about delimitation, I think time is going fast. Is there anything you would want to say about what you just heard, Ms. Young, as this is concerned? The point is that you people can start if they have not started already. And well, let's all hope that everything can be finished within 2 years. But let's start so that we can get to some concrete point. And what was set out just now, I suppose that's all in the document which you agree on.
Indeed, Madam Chair is correct to say the grievance mechanism is set out in the delimitation principles methodology. What the appellants are grateful to move this process forward, and it has definitely been helpful to know that there is a formal commitment going forward with this so that they can invest resources, access funding, and move ahead with this process. It has been helpful in getting this far, and for them now to go back to the land tenure facility and say, look, all indications are that both parties are agreeing to what has been submitted in the claim.
Okay, now I think this clarifies a lot about the documents that we have discussed. In your report, you also made mention of encroachments, alleged encroachments. As I said, most of those are before the authority. So we would not want to go into that now. We will wait what the authority has to say on those issues. And you've heard that her first decision is expected in about a week, and the others to follow from then to, I think, the end of July. So we can expect some decisions there. There was one point more generally made, that your people got the impression that the state, the government, was creating new privately owned lands in the Maya territory. So allowing private property. Is that just an impression, or is that something you could back up with some evidence?
Well, my instructions are that based on facts on the ground, that is what they have concluded, because there has been bulldozing, clearing of land, new owners asserting ownership to these, some resident, some non-resident owners, and they have been the subject of threats as a result of these assertions of these third-party land ownership. So it's based on facts on the ground that have actually arisen within the last few months, and which are the subject matter of the complaints that Professor Celorio alluded to, and which is included in the report.
Yeah.
But overarching concern, Your Honors, even though it is true the appellants have formally put these complaints before the authority, the overarching concern is the non-compliance with the undertaking under paragraph 4. And so the concern is that it's been several years, 5 years since the consent order, and 7 years even before getting to the consent order. And for the appellants, seeing that these incursions, despite the consent order, continue, the logging, etc., is affecting the tolerance, the patience of the Maya people in this entire process. So the overarching concern is that the Maya people are getting a distinct impression that all the 12 years have been, you know, a struggle for them, but they are not seeing any good faith on the government's part in restraining these incursions. And so that is an overarching concern for them. It's true that it's the subject matter of complaints before the authority, but if it is the case that it is the government that's issuing these concessions to log, fell timber, to explore for oil, that's a grave concern because there was an express undertaking. And so, yes, it could form, the authority can investigate and verify who is at the bottom. I mean, is it third-party licenses that have been recently issued post-2015? That could be ascertained. I think that would be very helpful in whatever steps the appellants take in terms of enforcement. But this whole process they have engaged in, in terms of trying to dialogue with the commission to move this process forward. But at the end of the day, they keep seeing these incursions, and it's of grave concern, and it detracts from the credibility of the process. So, as your honors will appreciate, the Maya people have requested certain things to be done. I have, we have considered all angles, but we thought this is a proper forum, given that the undertaking was given to this court, to emphasize that for the appellant, seeing these incursions really does not help the process along and is of great concern.
Okay, that's maybe the other side. Maybe Ms. Matut could react on this.
Yes, Your Honors. It's unfortunate that, in fact, that these incidents, as alleged by the appellants, indeed, in fact, continue to occur. But as there are matters that are before the author, to Professor Celorio, I wouldn't want to make too much comment. And based on the report that has been prepared by Professor Celorio, you would note some of our comments as it relates to some of the complaints that have been made. My learned senior had made mention of the oil exploration and logging. Based on the comments that we have submitted, Your Honor, it is clear that we, the government, we're not acting without consulting with the Mayas. All our actions that we are taking, or activities that the government wishes to embark on using third parties, we have taken steps to consult with the Mayas in an effort to get their consent. So to say that these activities are still occurring without consent from the Mayas and with the authority of the government, it's a bit harsh to say.
Okay, I think, they always come down on concrete cases. So maybe it's always difficult to talk in the abstract about this. So I think the best thing we can do at this point in time to wait the outcome of the complaints, and we can expect them pretty soon now. And then we can also see if there are any recommendations, if they have been followed or not, and so forth. So that will give us more concrete information about this issue. So I think I have to ask for some more patience, but only to get better information about these things. And of course, the Mayas are encouraged, if they see concrete incursions, to make their complaints, file their complaints, which will make it possible to give concrete decisions in those cases. Okay, so there's another issue, though, that I have to end with that, because in the status report of the government on the 4 and 5, there are some allegations in the direction of alcaldes and Maya villages. Also, as was mentioned, without evidence, but nevertheless, the allegations have been made. And I think I should give you, Ms. Young, an opportunity to react on that.
Grateful for that opportunity, Your Honor. This report, as Your Honors can appreciate, was only provided to us yesterday, and I sought instructions. And I think that we fully recognize here that alcaldes have no legal authority to issue any legal title to any third party. So for even the government to take these reports seriously is a bit of concern, because when you look under the National Lands Act and when you look at the Registered Land Act and the local legislation, there is absolutely no authority for any alcalde to issue land titles. So for even this concern to be raised in this report is concerning to us, because it's a report prepared by government, and they fully well know that alcaldes have no legal authority to issue any titles.
But have they?
No, sorry, Your Honors, no, they have not. My instructions are they have not.
Okay.
Your Honors, if with your permission, Mrs. Koch-Magnuson is also appearing with me and knows a little bit more firsthand and can be of greater assistance to the court in answering the allegation. With your permission, if I may allow her to address the court on that issue.
Yes.
Oblige.
But just briefly, because, I think you must have an opportunity to say that, okay, that might be true or not true, but we don't have to go into all the details, of course, at this point.
Much obliged, Your Honors. Thank you very much. That is very true, Justice Witt, that if these are the first times that we're hearing about these allegations. So we have not had time to confirm whether they're true or not. As you will notice that there are no names of villages or alcaldes. There's no evidence backing these allegations up. They're bold-faced allegations without much more. I leave it at that. However, if there are concerns that these activities are happening, we have a paragraph 4 authority for those complaints to deal with those. But these are serious allegations for us, because we want to preserve the status of our lands. We don't want them to be given away. And so we are going to look into the situation, and hopefully the commission can provide us with the information that they're alleging. And So we don't take these things lightly. We will look into them. But back to to whether or not the alcaldes have, the alcaldes are voted in or elected in by their communities, and they manage these lands. And so if it is that there's an alcalde doing something that is not by the permission of the entire collective village, then that is of concern to us, and I'm sure of the Toledo Alcaldes Association. And so for that reason, that is why we need these documents, these foundational documents, like the customary Maya land tenure policy document, the FPIT policy documents, the delimitations, because a lot of these things would fit into how we begin to resolve these sorts of conflicts on the ground in order to move the process forward. Thank you.
Thank you very much. Yes, I think if the commission has that information, yes.
Your Honors, nowhere, I just reviewed that report, nowhere do we state that titles have been issued. Letters have been issued, yes, but not titles. So I think that even if you're going to have the discussion about it, we have to be careful about what it is that we're stating. In regards to our reports, we have, as a commission, been advised not to take records of the complaints that have been coming into our offices, and we have dissuaded villagers from coming to our office to try to resolve these complaints, and we have in fact referred them to the Toledo Alcalde Association, as we believe that those matters should be addressed based on their customary practices. However, I have been strongly advocating that government needs to also report to the court that there are encroachments happening on private lands that have been occurring and are occurring and have been encouraged in these Maya villages. And so to state that only government is not in compliance with the order, fine enough, I will not argue that. But to also encourage a complex situation to become even more complicated, I think the court needs to be aware of it. This has been happening since we were established, and really, I'm starting to talk too much, but really what has been the recommendation that we got is that we don't become the entity where villagers are lodging complaints about these matters, or where private landowners are lodging complaints about these matters. So perhaps that is something that we should include in that, in the terms of reference of the authority, because I don't think that is included in that. The only thing is the complaints from the Mayas that they're making, the complaints the Mayas are making about government, but there's no mechanism in place where government or private landowners can also lodge complaints so the court is informed about what is actually happening on the ground. So I just wanted to state that.
Yes, well, of course, the order number 4 is, of course, an order to the government to comply. And I have looked at that too, but it's impossible to, I think, to go beyond that, because this is what we have to look at if the government is complying. Now, this could be a real issue, and hearing you, it is a real issue. But then I think I could ask counsel for the appellants to discuss this with their people and to make sure that they all understand what can be done and what could not be done. But we have to leave it at that, I think.
Chairman, if I may, and this is, I suppose, directed to you more than anybody else. I just wondered, sir, if the parties were willing mutually to allow for complaints by private parties, by the government, in respect of what is alleged to be intrusion by Mayan people onto private property, whether the scope of the authority could be extended to include that possibility, because it seems to me, and I agree with you, that it's not covered by our order, but it seems to me that that kind of means of resolving such disputes could in fact assist the overall project in going forward. So it can't be mandated, but if the parties were to mutually agree that any such allegation could go to the authority, that might be one step towards helping to resolve at a very preliminary level these kinds of issues.
Well, if they feel that they have the authority to try to agree to these kind of to this extension, then they could
That might be
certainly
something
try.
they could think about and come back
Sure.
maybe next time. Yeah.
Sure, sure. But as the case is, there is a limitation because of the order of the court. But anyway, the parties are free to discuss this because if we can create some peace within that area, then that would always be good. And that,
Mr. Chairman, if you allow me as well, the draft land policy, land tenure policy that I'm looking at speaks to empower the authority as an institutional mechanism for conflict management regarding possible incursions or unauthorized use of Maya land during the regularization process. So that I understand what Madam Chair is saying, the agreement would have to be expanded.
Sure.
But it has, though, enough concern to me, Madam Chair or Counsel for the Attorney General, I'm not sure who to direct this comment to, that a 6 months agreement and an extension for another 6 months may not be the sort of institutional mechanism that is properly required to bring, to look closely at this sort of conflict. Because it means that if there are, let's say, 10, 12 or whatever complaints, can these properly be done in 6 months? And then you have the situation where the authority is uncertain about the future, and there may be maybe part-heard matters not yet completed. And I just, it doesn't sort of ring right for me that we have these short-term contracts, that what is intended, as I see reading the land policies in draft, is that it be an institutional mechanism, and I would have thought that that would require some statutory framework. And so I am hoping that there's someone who is looking towards that sort of thing, because I would imagine that for the 2 years of this delimitation process, we may have these problems. And so we're looking at a proper authority that is properly appointed. And personally, I would think, Mr. Chair, through you, if I may suggest, with some statutory backing.
yeah, that would always be the best. This is, of course, an arrangement that has no legislative backing, but at least it is something, and it could work. But yes, the short duration of the appointment is problematic. I think in the framework we spoke about 1 year. I'm sure about that. And I saw that, okay, it was 6 months because of financial issues, etc. But I don't think in this respect that could be a good reason. But anyway, it's up to the parties, but to the government actually. But that would be certainly advisable that at least for a year with extension possibility, but maybe even for longer. But it depends also on the authority, which brings me to Dr. Celoria. Dr. Celoria, you have been able to follow what has been said. As I said, we don't go into the cases that are before you. But if there is anything of what you would want to remark at this point, which might help, I give you the opportunity.
Thank you, Your Honor, and thank you so much, Your Honors and this court for this opportunity, and thank you also for all of the work of both parties and all of the support that I have had, especially in the information gathering component of this process. I just want to say, maybe to end in a hopeful note, that within this process and my review of the complaints, I have seen some progress. I have seen some positive. I do see, in general terms, without referring to individual complaints, because I'm going to be issuing reports on those, that I do see a process, a government that is engaged, that understands the need to adopt steps to implement the CCJ consent order. I think the role of the CCJ and Your Honors has been crucial to get the government to a point like this, but I also see challenges, and you will see this discussed in individual reports. I'm particularly concerned about the ongoing logging concessions and authorizations and licenses. And one thing that I wanted to remark with Your Honors is that I am treating all of the complaints in terms of lands and claims that the Maya are raising and lands that they're using and occupying. And I'm actually issuing recommendations on all of the lands that claim that they use and occupy. I'm not making a distinction between what's private or what has a specific status at the government level. So that's going to be an interesting point to see in the reports. And I think that's a very important challenge that the government has, that many of the recent concessions are being granted on lands that are categorized by the government as private lands, which raises a level of complexity and, of course, a point that's going to have to be addressed in the demarcation, the limitation process, and even in new legislation. I am concerned about consultation processes, and I wanted to share that with Your Honors. The reality is that the government is trying to engage in consultation processes, and it's important that the government, that this is recognized, that the government is engaging in an effort, but most of these consultation processes have specific voids. They're not necessarily following international law standards or the specific components. And I think it's important to remark that most of this, the Maya peoples and the villages and those involved from the Maya side in these consultation processes are not in the same negotiation position. So that's something to keep in mind. And I wanted to raise in particular, Your Honors, the threats. One thing that really concerned me when I was in my visit in March of this year was the fact that many Maya representatives were very scared of talking to me. They commented that they were afraid that third parties were going to actually threaten them or commit any sort of acts that would threaten their life or personal integrity just because they were revealing information to me and because they were challenging the notion that these third parties should be doing these incursions on their lands. I'm very concerned about this. I've shared this concern with the government authorities. I share them with you, Your Honors, as well. I think it's an important point for the government to monitor in the immediate future. I think this is very urgent. And another thing that I want to project to Your Honors is that one thing that really impacted when I was in the visit was the pain of the Maya peoples and the representatives, the way they alarm insecurity, the way they feel about these continuing incursions. And I think it's important to remember how close of a relationship they have to their lands and their territories. For them, this is part of their life plans. For them, this is basically part of everything that they have. And this ongoing context, aside from all of the documentation, aside from the CCJ consent order, is provoking a situation of insecurity, of legal uncertainty, And I really hope that my mandate and the reports that I'm issuing provide constructive guidance to the government to be able to move forward and to be able to use it as an input in the processes that we have been discussing today, the demarcation process, the limitation process, the legislation process. I hope that they can be some sort of input and guidance in this process, but I just wanted to communicate those points to your honors. And I'm very open if you have any other questions. And thank you so much for this opportunity. I feel that performing this role is an honor, and I'm really trying to help with this situation.
Okay, thank you very much. I think at this point, I don't know if my colleagues have any questions. I for myself would wait with that and see your reports and see what happens with those reports. I understand that. I hope I understood you correctly, that you said, okay, when I finish a report, I will send it first so that I can get comments and then I finalize it.
Yes,
Okay,
Your Honor.
Yeah, that's a very good method. So any concern from any side could then still be looked at before you finalize the report.
And Your Honor, if I may, I just wanted to add that for me, it's been very, very important throughout this entire process that the parties have sufficient spaces to communicate their concerns, their perspectives.
Right.
I can identify at least 6 instances in which they have been able to do that. And for me, it's very important that whatever reports are presented before your honors, that are reports that also include their comments. So that you kind of have a fuller view of what the situation is on the ground. I just want to make sure you have reports that really are credible and can be useful in the monitoring of this matter.
Sure. Well, thank you very much. I think you can expect more complaints once the process starts rolling, and maybe provided that some action is taken, that will get back some confidence in the system. We all realized, the court realized 5 years ago when it gave those decisions, those orders, that they were all very good sounding orders, but that would only be the beginning of a long project to get things done. That's in the details, that's where the devil is, they say. So it is a process that takes enormous time and energy, but we have seen that from both sides enormous energy to get to results. They are coming slowly, but I think we're still hoping with some confidence that we will reach those results that we are all hoping for. In the meantime, it's not easy. We are aware of that, but anyway, we thank you for your acceptance of that role of the authority. I think it will add a lot to the process, and we wait with bated breath to see your decisions and your recommendations, and of course we also will see what happens to that. So thank you very much for your presence today.
Thank you, Your Honors.
Your Honors, can I ask?
Yes.
Can I just ask? Well, we spoke about earlier the complaints of encroachments on private lands.
Yes.
And you've stated very clearly that this is not a matter that is addressed in the consent order, and therefore anything that would be done would need to be required to be done voluntarily. Yes. Between the two parties, because then the other option is for people to take all these matters to court. Yes. Right? Okay, and yes. That is my main concern, and my motivation is that these concerns are not necessarily with non-Mayas. It's conflicts with Mayas amongst themselves in these particular villages, whereby there are issues of reports of encroachments on lands.
Yes.
So I
think-
just wanted to add that this is not necessarily an issue whereby all of these are huge landowners that are non-Mayans that are complaining, but the majority of the issues are the same Mayans in the villages who hold land privately, who have complaints about these matters.
Yes, I suppose hearing Dr. Solorio, I think she will address some of these aspects in her decisions. So let's wait and see what that would be. And then I think parties can always discuss to broaden the scope if that is a necessary thing. So it would go beyond the court's order, but if you want to add that and it makes sense, and both parties thinks it makes sense, and the authority is willing, then you could try to get to that kind of arrangement. Because it is important that we have some peace in the area, and that it is clear that, for example, indigenous land rights are communal rights. So the idea that you can, as part of indigenous rights, have a private property, that seems to be conflicting with it. That's the system that we have from Europe. But anyway, those are complicated issues, and they have to be worked out. So parties can always discuss this and see how far they get. For the time being, unfortunately, it's the government that is going to be scrupulously looked at, but and that will give work enough for the time being. But it can always be broadened if necessary.
Mr. Chairman, as you are, and I suspect you are, winding down, I wanted to, I thought you were. I wanted to just raise one issue with Council for the Government. And in fact, in doing so, I'm going back to where we started, because we started with the question of the customary land tenure policy, which we all agreed had been with the government now for over a year. And we need to, I think, get some clarity as to when we're going to get a response from the AG's office on this matter. So I don't know whether Council Ms. Matute could advise us, please.
Your Honor, unfortunately, I am not in a position. I'm not sure if you're hearing an echo. I'm hearing an echo on my end.
We don't hear an echo. I don't hear an echo. So.
Yeah,
Yes,
please go on.
unfortunately, I am not in a position to see how much longer it will take for the government to have a response in relation to the customary land tenure policy. However, I can undertake to at least find out what the status is from the government, and by the time the court sets its next report date, by then I should have an update on where we are with the policy.
And would you also include in that undertaking the conveyance of the chairman of this hearing, that the matter has been under consideration now for quite some time? And
Yes,
that
Your
in
Honor,
order to satisfy the requirements of the consent order given over 5 years ago, there needs to be expedition in deciding on this matter.
Yes, Your Honor, I will express the concern of the court in that regard.
Good.
Okay. Can we discuss a new date already, or? I think we can expect decisions from the authority from in the cases that are before her. We will have all the decisions by the end of July, successively. So then there might be some time we have to see what's going to be done with it.
You know, Chairman, we were also, I think, talking, admittedly, in very hypothetical terms of when is it that certain documents and the policy papers will be submitted to the government. And we
Yes.
thought around it August or thereabouts. I think the intention, the indication was that that might have been a bit ambitious. So I don't know if by September, for example, the documents would have been submitted or be on their way to being submitted, and therefore a hearing in that time context would make sense.
Yes, we're officially in recess then. So maybe the first week of October, would that be convenient? Ms. Young, unmute.
Yes, Your Honors, that would be convenient for all. For the appellants, of course, we would always want a sooner date. But if that is the soonest date that all parties can be ready, but we would prefer a sooner date, Your Honors, because it's only your intervention that we believe has gotten us this far.
Well,
Of course, I speak subject to what the chairman says, but I do think that we want to be in a position where we can see measurable progress. I don't think there's any point in our meeting and just sort of, tossing papers around. We want to know that the delimitation exercise has started. And we want to have a report on what is going on there. We want to know that the policy documents, which is the FPIC, the redress mechanism,
yeah.
that has been submitted to the government. We want to know that the 10-year policy has been approved. If not approved, we want to know why it has not been approved by the Attorney General's office. So we want to give enough time that there can be measurable progress so we don't keep repeating like, this kind of hearing without seeing something tangible happening on the ground.
And as you understand, everything that has been said is recorded. So all the things that have been promised, we have noted down. And that is the first thing we will ask. So I think I understand what
Your
you...
Honors,
Yes, please.
can I intervene and just say that we have no objections to bringing up the date and aiming for August, because as you're aware, this is a election year, and I don't know by October where we will be.
Okay, so when is the election going to take place?
Well, the latest it can be is in November.
Oh.
So by that time, I might not be around anymore. So, so I would want to aim for sometime in August.
Well,
perhaps the latter part of August. Is the court open in August? I don't know what.
Well, the court is on recess normally.
Oh, okay.
But I don't know now with all these COVID issues. It might be that we are. The point is, where do I go to on vacation?
I think the court will, and I'm sure I speak for my sister here, will respond to the chairman's bringing us together in August if that's necessary, from wherever in the world we are. We will do that. But the point is that there has to be reason for us to meet. And there has to be measurable progress, otherwise there's no point in meeting. So the question then is, well, what can be done between now and, let us say, the end of August? Can we kind of compress the kind of activities that we're thinking about? For example, can we try and get the documents, the policy documents, to the government so that they have an opportunity to sign off on them before the elections take place?
Okay, I can commit to aiming, as long as the mayors are equally on board, to having the FPIC and the grievance redress mechanism at a very advanced stage, if we agree, or at least at the stage whereby it has been submitted to the policymakers to address the matters where we don't coincide in our positions. I think that is doable. In regards to the policy, I mean, that there's nothing to stop, nothing except urgency on the regards of of the officials in the Ministry of the Attorney General to allocate the time to review that policy document and to indicate to us whether we need to go back to negotiations.
Perhaps.
So I can't commit on the policy, but I can commit on the FPIC and the grievance redress mechanism that at least by August, you wouldn't be wasting your time by calling a session, and at least we should have those, which I think are critical documents if we're going to reduce the number of complaints that are being filed with the authority.
What about
So-
the beginning of September, Chair? Do you think that might work? Beginning to the middle of September?
Well, yes, the point is, as you see now, wherever we are, we can still have a sitting.
Yes.
So that wouldn't be a problem. First week of September, for example, which give you a little more space, but it's still earlier than what we thought, so a month earlier.
One of the problems,
It's
though, you know,
important that we keep the pressure on, so to
yes,
speak.
yes, Chairman. And one of the problems is that, of course, if we're talking about approval of the policy by the policy maker, that policy can be disapproved of quite easily after the elections by another policy maker.
Yes.
It's not quite as easy if it's in legislation, but I don't think we're going to be able to get there before the
No.
election. But at the very least, if we had something agreed by the present administration, then I think that would make for some progress. So
Yes.
I believe if we can get some documents in, Madam Chair of the Commission, by the middle of August, you know, I think that if we met then, say 3 weeks after that, then that might be useful. And Ms. Matute, if we could convince the Attorney General's office that we really need to hear something, please, by the middle of August, then that would also be helpful. And Ms.
Yes,
Young,
ma'am,
if
I
we
will
could
give
start on the delimitation exercise, please, so that we can have a report.
Yes, my instructions are that they've started and they are prepared. They would be ready to give a report of how many villages have already embarked and how far they've embarked on the auto delimitation.
Excellent.
By early September.
By August is what the appellants are indicating.
Okay.
Okay, so first week in September would be a good week to have another monitor hearing. That would be when? Let me see if I can get
I think we should give Madam Justice Rajnath Lee an opportunity to nominate a date, because I rather suspect, given that she sometimes travels quite extensively during the court vacation, she might wish to have special dates.
I don't know.
You
I don't
are,
know.
you are very kind, Justice Anderson. But I
As
can
usual.
only suggest to all of you who are in Trinidad and Tobago with all that is going on, that Tobago would make an excellent place to have a vacation. Well, we have independence on the 31st of August, and we have that very first week, which September the 1st is a Tuesday.
Yes.
So I don't know if we want to do it the following week, which would be, let's say, Tuesday the 8th of September. Just a suggestion.
Works for me, Chairman.
Yeah, that would be fine.
What about the parties?
It works for the appellants, Your Honors.
Okay. Then,
Convenient for us as well.
excellent. So then we will have a next hearing on the 8th of September.
Any time, Chair?
Yes, I think same. Well, normally we take 11 o'clock Trinidad time, which would be 9 o'clock Belize time.
Yes. That
Um,
would suit me.
okay, so 11 TT time, 9 Belize time. We expect, of course, then in the week before some reports. Of course, if there's something very urgent, then it can always be filed at an earlier stage, but only in very urgent situations. But normally we will then hear everybody on the 8th of September, 9 o'clock Belize time. But I don't know yet whether that will be in this manner, or that we, well, probably for this you will not fly to Trinidad anyway, but we might sit in court without or with masks, or we do it this way. I think this is better.
I think this is better, Chairman.
I agree.
So from our houses, you see it works perfectly. We could hear you very clearly, everybody, and there were no problems whatsoever. Okay, well, then I thank everybody for being here, and also Dr. Solorio for her presence here. And we will wait the results from her investigations and further reports from the parties to see how things are going. And once more, we have recorded everything, so all the promises are noted. Thank you very much.
Chair.
Thank you all.
Thank you. Thank you, everybody.
Thank you, Chair.
Okay, bye.
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 Bye.